Donnie has sent us a very, very good question. And his question goes a little like this. I had to sign an arbitration agreement when my mom went into the nursing home 6 years ago. Is that agreement still enforceable? Gentlemen?
Well, you know, a lot of them do that now. It certainly is faster and cheaper than having to impanel a jury of 12 people to hear a complaint. So many of the nursing homes include that arbitration agreement in the paperwork that you sign before you go in. We have had cases like that. Generally, though, we feel like a jury is more liberal and treats you better if you have a legitimate complaint against a nursing home than will an arbitration board. And the arbitration usually is binding. However, normally, and BJ is a lot more conversant with this than I am, we have had cases where a person has gone in, signed in by their family member who simply did not have the authority to bind them to arbitration. And therefore they weren't held accountable to that clause. Now, if it's the person themselves, if that's correct English, if it is the person, his or herself signing them in, and they are competent, then of course it would be binding. But BJ, you recently had a case where we had an issue and brought an action against a nursing home where the person who signed the patient in did not have the authority to do so. You remember that?
Yeah, we've been dealing with this issue, seems like probably 10 years. You know, the nursing homes put it in the agreement. When you sign all the admission paperwork, there's a stack of documents an inch thick, and at the very bottom, hidden in there, is a little provision that says that you're waiving your right to a jury trial and you're agreeing to binding arbitration. And we've been fighting, plaintiff's bar and the defense bar have been fighting the validity of those. And the legislature's gotten involved a little bit, but Carl is correct. It comes down to simple capacity to agree, a contract situation, where if the patient is lucid and competent, he or she can go in and sign an agreement of arbitration, and the courts will uphold that. But in this case, Donnie signed it for his mother, unless he's the agent of his mother, has power of attorney perhaps for his mother, or is somehow the legal agent of his mother, then that agreement's not going to be binding on his mother's personal injury case. But if she had signed the agreement, it would be, and it goes so far as if she would sign the agreement, enter the nursing home, and then 6 years later die, then it would also bar her heirs from pursuing a wrongful death case, because that was a recent case out of the Supreme Court said that was a derivative action. So those cases would be barred as far as a jury trial. But we had a case, Judge Colvin from Macon, who just got appointed to the Court of Appeals in the last month or so, decided a case where the person signing the agreement had the advance directive, which is what sounds a lot like a power of attorney. It sounded like they were going to be held binding, but Judge Colvin said it wasn't, that it was not enough. So the arbitration clause was not enforceable in that case. So we're still fighting it, still trying to figure it out and understand it. But like Carl said initially, it comes down to whether the person signing it has the authority to do so.
Yeah, and I'm gonna take this advantage, this opportunity too, to throw out a plug for Judge Colvin. She's just been recently appointed to the Court of Appeals, and she is a judge's judge. She is an awfully fine judge.
Yeah, she's
and
awesome.
One thing I feel like I'm compelled to mention, since I spoke earlier about going to YouTube and seeing some of the examples and the fact that some things are obvious, whether it's a bruise or a cut or a bed sore or a fall. A lot of people are a risk for a fall, and the nursing homes have to take special care to keep those people from falling. But here's one that's not so obvious, and it's a story I'll tell if I've got time, and I don't know how much time we've got left in this section. But we had clients one time who had put their mentally challenged daughter in a nursing home. She was 44 years old, and she was pretty severely challenged mentally, and was supposed to have been put in there and taken care of 24/7. Well, it turns out that there was a person hired, one of the staff members in the nursing home was periodically raping her. and she didn't have the capacity to even complain about it. And this went on for weeks and weeks and weeks. And of course, it was finally discovered. We took the appropriate action. He was actually sent, the staff member who was doing that was actually sent to prison, but the nursing home had to pay monetary damages to the family because this man had a record which they had simply failed to check. So there's a such thing as negligent hiring on the part of the nursing home. They need to know, they need to do their due diligence in looking at the people they hire to take care of these people who you put your trust in the nursing home and in the people they hire. And when you put your trust in them, they have a responsibility to make sure that they have competent, good people who are looking after your loved ones. So just put that in the back of your mind if you're listening to this and you're coming to that point in time that you might have to use one.
That's good information. Thank you for sharing that. Carl Reynolds and BJ Savannah are our attorneys tonight. We're discussing nursing home negligence.